So I'm Chris Nell. I'm the internal arbitrator of Old Mutual. My role is similar to that of an ombudsman, but the title or the term ombudsman is reserved for external ombudsman, like the ombudsman for long-term insurance or the phase ombudsman. So someone who does that type of role inside an organization is only allowed to call itself something other than an ombudsman. So that's why my title is internal arbitrator. The three things that I would like to share about what I think underwriters should know about what ombudsmen do, and an internal arbitrator like myself, is firstly, it's important to distinguish between the concepts of justice, law and equity. Law is a tool to try to achieve justice, but it is an imperfect tool in the sense that it is of very general application, and the strict application of the law can lead to a result that is unfair. And that is where fairness, or also called equity, has to be applied to temper, in some instances, the effect of the law. So that's important to know. The second thing that I want underwriters to understand is the importance of doing your job properly, because the decisions that you make can have serious implications for your organization, but also for the customer. Because of the fact that in most cases underwriting is done, full underwriting is only done at claim stage and not at proposal stage, if there is something wrong with the underwriting or non-disclosure is not discovered, it can have severe consequences for the beneficiaries or the people who are supposed to benefit from the insurance. So that's why underwriting at, the basic underwriting at proposal stage is so important. To do it properly, one has to take into account all of the information that is disclosed, and if there are inconsistencies, that in itself should prompt you to probe further. Do not make assumptions, because those are dangerous things in the world of underwriting. If the assumption is incorrect, you can be regarded to have been negligent, which would mean that the law will say that the insurer cannot rely on the normal ground for avoiding liability on the basis of non-disclosure. If a reasonable underwriter would have asked more questions, and whoever the ombudsman is who is deciding whether a reasonable underwriter would have asked for more, if they do think so, then the insurer is not allowed to avoid liability. So it's quite important to do your job properly. And the third and final thing that I would like to say is that if you are faced with insufficient information, do not be tempted by pressures for production or anything else to let go of what you think is really important. Rather take more time, even if it affects your production, because as I've explained before, if you should have probed more or insisted on more, or insist on anything in particular and didn't, you run the risk that an ombudsman or a court of law for that matter can say that you should have, and then liability cannot be avoided. So rather than look after quantity, rather look after quality. In the long run, it is better for everyone. Thanks.